property. We're delighted to have as our inaugural speaker this year Professor Lessig from the Stanford Law School faculty. And in a moment I will ask his close friend and colleague and also our colleague, Professor James Boyle, to introduce Professor Lessig. First I want to acknowledge and express our gratitude to Kip and Meredith Frey, whose support has made this lecture series possible. Kip and Meredith, would you stand up just for a second so we can recognize you? Graduates. Since taking his degree from Duke Law School in 1985, he's established himself among the country's leading startup CEOs with successes that have acquired an aura of legend among the new generation of entrepreneurs and venture capitalists. To give two examples, in the year 1999, Digital South magazine named Kip the top CEO in the Southeast, and North Carolina Electronic and Information Technology Association named OpenSite, which was his company at the time, the software company of the year. Together, Meredith and Kip have committed themselves to the community in which Duke is playing a role. As a continuing member of our extended community, Kip regularly shares his professional knowledge and expertise with our students, including a course he now teaches with David Lang in the legal dynamics of the startup environment. With Meredith, he has joined the law school on other occasions in our efforts to establish an intellectual property program at Duke that can stand with the best in the country. We have come to count on them for good advice and counsel and generous measures of personal effort. This series of lectures then reflects the continuing warmth which characterizes their relationship with the Duke Law community and ours with them. Meredith and Kip, I want to just indicate our great pleasure in having you here today and to thank you publicly for your contributions to this law school. There are still a few, there are no more seats. Not even cheap seats are available here. One or two more seats down here in front. James Boyle.
Thank you. Welcome, everyone. Welcome in particular to the members of the admitted class. I want to reassure you that there are often seats at Duke Law School. When you come here, you would many times be able to sit down in your class, and you would graduate with enormous calf muscles, which would be the envy of everyone around you. This lecture is simply a rather popular one. It really is a great pleasure to be here today. This is the inaugural Meredith and Kip Frey lecture on intellectual property. You always try your best. In a lecture, you try your best, particularly in an inaugural lecture, you want to set the tone for what follows. When your inaugural lecture is one that is created and named for two alums and one colleague and two benefactors, then you try particularly hard. And as I promised Larry, I would say, in introducing him, we couldn't get a better lecturer today. No, seriously. Professor Lessig is simply the ideal person to have here, and I'm just going to say a few words about why that is. Larry Lessig went to Yale Law School, clerked for Judge Scalia on the Supreme Court, taught at Chicago, Yale, Harvard, and now teaches at Stanford, and finally managed to come to Duke, sort of working his way slowly up the meritocratic hierarchy. He's a person who has had, I think many scholars who sort of look on the work from the outside would think of his work as really being sort of twofold. He's had, in effect, two careers, they might think. The first is as a constitutional theorist. Professor Lessig has written a body of work on the interpretation of the Constitution, dealing with the question, should the Constitution be interpreted according to the original intent of the framers? His response is that to reject what he calls a one-step kind of originalism, simply find out what people thought about the meaning of the Constitution at the time the Constitution was framed and ratified, and instead argued for a different kind of interpretation, which he described using the metaphor of translation. He says the translator's task is always to determine how to change one text into another text while preserving the original text's meaning. And by thinking of the problem faced by the originalist as a problem of translation, translation may teach something about what a practice of interpretive fidelity might be. In other words, Professor Lessig is arguing that were one to take simply the view of the framers, say, on what the Eighth Amendment meant at the time, or the view of the framers about the meaning of the copyright clause, that one would miss something, because what one needs to do is to understand the meaning of that text in the current context. Translation always includes both text and context. And he argues that this is actually what true fidelity to the Constitution requires. Not quite clear whether Justice Scalia was exercising his translation skills in Bush versus Gore, but that's an issue which I won't get into here. The second career that it might seem scholarly career that Professor Lessig has had, and the one which I think has brought him a much wider circle of admirers and a wider circle of readers, certainly, is in writing about the law of cyberspace. His book, Code and Other Laws of Cyberspace, has been extremely influential. In it, he argues against the complacency of internet libertarians who believe that the internet automatically and technologically brings about a certain kind of human liberty, and the governments can't regulate it anyway and shouldn't regulate it because they're bad at everything they regulate, but that the internet, through its technology alone, will carry us forward into a brave new libertarian, digital libertarian world. Lessig argues against this using a different metaphor this time, not of translation, but of two types of codes. He says that there are two types of codes we need to focus on here. One is the kind of code that you would learn were you to come to Duke, or if you're already at Duke, East Coast code, law. That is to say, the laws that regulate society and that in part have tried to regulate the internet. This is the kind of code that we learn to read, interpret, and translate. But the second kind of code, the kind that Lessig has argued receives insufficient attention, is West Coast code, software. The code that actually constitutes the internet, the code, the logical layer that determines what one does on the internet, whether or not the internet's protocols are open or closed, whether or not the internet requires, permits, or forbids anonymity, whether or not the internet allows certain kinds of geographical tracking, makes them hard, or makes them impossible. All of these things, Lessig argues, are as fundamental in constituting the internet as a social space as the legal frameworks, the East Coast code that lawyers deal with. In fact, he argues, perhaps they're more fundamental. And so we should pay as much attention to this West Coast code, this software, this constitutive code that writes the constitution of our new social space in the internet, as we pay about the East Coast code. And in fact, he argues, we should use exactly the same techniques that we do when we think about the Constitution and the Constitution's values. Are these then two separate careers? I would argue actually they're not. In fact, it seems to me that although most people would see the work on original intent and the Constitution on the one hand, and the work on cyber law on the other hand as being deeply distinct, they are in fact linked by the central theme, namely, Professor Lessig is trying to show us what fidelity to constitutional values mean in the context of the internet. And today, in a speech, and I have no idea what the precise topic will be, today, Professor Lessig is going to transpose some of those concerns and intellectual interests into the world of intellectual property. Larry Lessig, thank you.
Thank you, Dean, and thank you, Jamie. I thought I had two ideas. It's a little bit depressing to see that I've only had one. It's difficult enough for me to imagine people actually suffering through a substantial lecture of mine sitting comfortably. This is a little bit anxiety-producing, the idea that we must suffer through it physically as well. So I really encourage you to sit down or go get coffee or something. Whatever would make it easier. Okay. Every society has resources that are free and resources that are controlled. A free resource is a resource that anybody can take. A controlled resource is a resource that only those with permission can have. E equals MC2 is a free resource. Anybody can take that and criticize it without the permission of the Einstein estate. 112 Mercer Street in Princeton, New Jersey is a controlled resource. To sleep there, you need the permission of the Institute for Advanced Studies. A time is marked not so much by ideas that are argued about, but by ideas that are taken for granted. The character of an era hangs upon those ideas one need not question. The power of a particular moment. It runs with the notions that only the crazy were drawn to doubt. Now, sometimes that's just fine. I mean, it would be terribly tedious to have to argue about infanticide every time the issue came up, or whether we ought to remain a democracy. It's a great thing in the language of computer programming that some ideas have been compiled into the social life that we know. It would be an awful thing if every value must at every moment be interpreted. But sometimes a society gets stuck. Sometimes an idea sticks with society. And when this happens, the hardest part of social and political action, the hardest part of changing at least part of a society, is to get people to see how this taken for granted idea might be wrong. To get people to believe that there might be something contested as unquestionable, or to get them to see that the story is more complex than they thought. And so it is with us. We live in an era when the idea of property is just such a thought. Or better, just such a non-thought, when the importance and value of property is taken for granted, when it is impossible, or at least for us, extremely hard, to get anyone to entertain a view where property is not central, or to question the universality and inevitability of complete propertization, is to mark yourself as an outsider, as an alien. I don't mean the debate crystallized by feminism, generally, or this dean in particular. I don't mean the questions of commodification or whether we conceive of social relations as property rights. That's a fundamentally contested discourse, rich with possibility and profound insight. I mean something much more mundane, something much more simple. I mean the question of property in resources. The question whether resources should be controlled, or more properly, how they should be controlled. For about this question, there is apparently no debate at all. As Carol Rose from the Yale Law School puts it, we live in a time when the view is, quote, that the whole world is best managed when divided among private owners. The most creative of our public policy minds get turned to the question how best to divide up resources. The assumption is that well-divided resources will always work best. We have this view, this taken for granted, uncontested background view. Because for the last 100 years, we've debated a related question, and that debate has come to an end. For the last 100 years, the question exciting political philosophy has been, which system of control works best, the market or the state? And that question, we all rightly believe, has been answered. In all but a few cases, for a wide range of reasons, we know this, that the market is a better tool for controlling resources than the state. That between their two, there is no real debate anymore, that it is the communists now who roll on the dustbin of history. But this confidence obscures a much more fundamental question. This certainty about the market over the state leads us to ignore a much more basic issue that comes before. Not the question of which system of control is best for any given resource, but instead the question, should a resource be subject to control at all? Not the market versus the state, but controlled versus free. If communism versus capitalism was the really tired and depressingly boring debate of the 20th century, then control versus freedom is the debate of the 21st century. If our question then was how best to control, our question now will be whether to control, whether a resource should be free, and what free resources give us that controlled resources don't. What is the value in avoiding systems of control? Now, this is a hard question to ask here at Duke. It's actually a hard question to ask anywhere, as it usually elicits a kind of sheep-like response among the audience. But here, in particular, it's hard to ask, because it's been answered here at Duke many times before. This controlled versus free debate got reborn within the law in an essay about the public domain penned by Professor Lang. The paradox between control and freedom is crystallized in the first great book of this information era by the romantically denying the romance and authorship Professor Boyle. And the struggle to preserve the space of the free in the core of that place where it's done most work, science, has been the energy and power of the work of Professor Reichman. And so here is the real struggle of one invited to speak at Duke, to speak of things learned from Duke. The exercise quickly feels less like a lecture, more like an exam. I look up at every moment to see how I'm doing. I sat leaning at my desk as I wrote this, thinking, what could I possibly say to these people that would be new? And then I thought, well, this just shows how much what they've taught us is true. There's nothing really new out there. Even what I say won't be so new. That every work of authorship is the recombination of what's gone before. Let me recombine what they have thought in a way that says something a bit different. And so here's the way I want to put your argument. I want to translate your arguments, that's right, only one idea, into space, into place. I want to place them within an architecture, and then to demonstrate the points that you've already made through the machines we've come to know, through the machines that have designed and defined a potential for a new kind of freedom that we as a culture have not known for a very long time. NYU law professor Yochai Benkler is a theorist of free communication. Not free speech, but communication. Benkler says, think about a system of communication as divided among layers, 3 layers, each depending upon the other, each interconnecting with the other. At the bottom, there's a physical layer. The wires that connect the telephones, the wires that connect the cable that broadband is broadcast across. Above that physical layer, there's a logical layer. The system that controls who gets access to what, or what gets to run where. And on top of the logical layer, there's a content layer. The stuff that gets said or written with any given system of communication. Now, each of these 3 layers could, in principle, be free or controlled. They would be free if they were organized in a commons, which means organized so that anyone could get access to them on equal terms, whether they had to pay a fee, a fixed price, or not. They would be controlled if they were the property of someone else, someone who had a right to exclude or to grant access or not based on his or her own subjective reasons. And depending upon whether these resources are free or controlled, we build a very different communication system. Think about 4. Speaker's Corner in Hyde Park, London. Speaker's Corner is a communication system where loons gather every Sunday to scream at each other in ways that are incomprehensible to the rest of us. They gather in a free space. The physical layer is a commons. They speak in a language that is open and free. The logical layer, the English language, even that weird version of it over there, is free. And the content that they utter would not be, no one would want to own that content. So this too it is a communication system with freedom at all three layers. Now think about Madison Square Garden. Madison Square Garden is an owned physical space. People rent it out to give lectures or to hold conventions or sometimes play sports. That is a physical layer that is owned, but on top of that owned physical layer, there can be speeches, sometimes in English, that's free, and then the content on top of that can also be free, depending on what's uttered. Think about the telephone system. The physical layer is owned. The wires of the AT&T monopoly, at least, were owned by AT&T. When AT&T was a monopoly, the logical layer, too, was owned. Who got to connect to what was a function of how the system was designed. AT&T designed it. But the content layer, what you said, was free. You got to say what you want, subject to some laws about profanity. And finally, think about the cable television system. Physical layer owned, the wires coming into your house. Logical layer owned, how things come into your house. Content layer owned, what gets processed in the cable television system, except for some small. This then is a range of ways of architecting a communication system. A communication system, and hence a system for innovation. Any system of communication could be among this, one of these four. But the four set up a way to help us understand the one I want to focus on here, the communication system called the Internet. It's a commonplace to say that the Internet is a kind of commons. It's less commonplace to actually have an idea what a commons is. But by a commons, I mean a resource that is free in the sense that I've described free resources so far, not necessarily zero cost, in the words of the greatest philosopher of our era, not free in the sense of free beer, but free in the sense of free speech. If there is a cost to this access to this free resource, it is a neutrally imposed cost or equally imposed cost. Central Park in New York, in this sense, is a commons, a rich resource made available to anybody. The public streets, in this sense, are a commons, open to anybody on your schedule. You don't have to get permission before you go downtown. Fermat's last theorem, in this sense, is a commons. Anybody can pick it up and try to work it out, as Andrew Wiles did, after a struggle of a lifetime finally solved. Open source or free software is a commons. It lies available out there for anybody to take because dedicated to a rule that says anybody can take and use this under terms set equally. These are all commons because they are within the reach of the relevant community without requiring the permission of someone else. They are resources that are protected by a liability rule rather than a property rule, as, for example, Professor Reichman has suggested some innovation be protected by liability rules rather than property rules. The point is not that there's no control present. The point instead is that the kind of control is different from the kind of control we typically grant to property holders. Now, the Internet is a communication system. It, too, has these three layers of access. At the bottom layer, the physical layer, are the wires and the computers, and the wires linking these computers. These resources are owned. The owners have complete control over what they do with their wires and computers. The wires linking the computers are not subject to any general compulsion by others. Property governs this layer. But on top of the physical layer is a logical layer, the protocols that make the Internet run. These protocols are many, all chunked into a single box called TCP/IP. Their essence is a system for exchanging datagrams, but we miss something important if we speak about the system focused exclusively on this essence. For at the core of this logical layer is a principle of network design. At the core of the Internet's design is an ideal called end-to-end. First articulated by network architects Jerome Salzer, David Reed, and David Clark, end-to-end says build the network so that the intelligence in this network rests at the ends in the applications, and that the network itself remains simple. Simple networks, smart applications. Now the reason for this design was simple. With end-to-end, innovation on the internet did not depend upon the network. New content or new applications could be run regardless of whether the network knew about them. New content or new applications would run because the network simply took packets of data and moved those packets along. The fundamental feature of this network was neutrality among packets. The network was simple or stupid, as David Eisenberg calls it, and the consequence of this stupidity, at least among computers, is the inability to discriminate. Innovators knew that if their ideas were wanted by users of the network had no power to discriminate against them. This was a network architected never to allow anybody to decide what kinds of innovations would be allowed. This means that this layer of the network, this feature of the network that distinguished it from every other telecommunications network in the past, built this network into a commons. It was, in the logical form, a commons made available across the board without discrimination. The protocols were designed for sharing, not exclusive use. Discrimination at the heart of a property system was not possible at the heart of this system. The system was coded to be free, and that was its, quote, nature. Thus, on top of this physical layer, which was controlled, was a logical layer that was free. And then on top of this logical layer was a content layer that was both free and controlled. The free part is all the content that effectively rests in the public domain. The facts, data, abandoned property, undiscovered theft. That's the content that's open for anyone to take and that is being taken openly. But the content layer, the free part of this content layer, is also a part that's dedicated to be free, dedicated to be open. This is the open source of free software content. This free resource does more than entertain, or more than just build culture. This free resource teaches the world about how this resource runs or functions. Its message is its education that teaches the world how to build out this space. Like every web page that both displays and carries its source code with it so that the source code can be copied and modified for many different displays, this feature of the internet made the education that built the internet possible. Nobody really learned HTML by reading an HTML manual. They read it by stealing web pages of other people and changing them to make them into their own. I did this with my wedding web page. I changed a few things, but basically it was not mine at all. But that's how I learned HTML, by this theft and education. This free content, though, coexists on the internet with controlled content. Software that is sold, digital content, music, movies, greeting cards that is controlled. You can link to mp3.com and listen to music that's free, and you can also listen to music that's controlled. You can link to amazon.com and download books that can be read anywhere, or purchase books only through systems of control. The network doesn't care much what linking occurs. It's neutral among these different kinds of linkings, and the result of this neutrality is this mix. Now this is the picture of the complexity that we call the internet. At the bottom, controlled. At the middle, free. At the top, both free and controlled. And this complexity builds a commons, an innovation commons. And this innovation commons has been the location of some of the most extraordinary creativity that we as a culture have seen. Not just innovation in the sense of .com, but innovation in the way that humans interact, innovation in the way that culture is spread, and most importantly, innovation in the way that culture gets built. The innovation of the internet, built into its architecture, is an innovation in the ways in which culture gets made. Let the .coms flame into non-existence. It won't matter to this innovation. The crucial feature of this space is the low cost of digital creation and the low cost of delivering what gets created. Now, I dissected this commons into these layers to help us see more precisely the dark side of the story I have to tell, to show you how it's about to be enclosed. For my message so far has been fairly bright, but my brand is pessimism, and so I need to get back to the brand. With a good dollar here. And the thing is, darkness is not hard to find. For though we have just begun to see how this freedom on the internet really functions, we're coming to see quickly how this freedom is being removed. These layers, mixing free and controlled, are quickly becoming layers that simply mix different kinds of control. We are in the middle of a process by which, through law and technology, these features of the original design of the architecture of the internet are changing. Because we believe, quote, the whole world is best managed when divided among private owners, we are changing the architecture of the net to enable it to be divided and controlled. Because we believe, quote, the whole world is managed best when divided among private owners, we are expanding and reinforcing control over content through IP law. Because we believe, as our ideology says, we are remaking the internet to fit this ideology without even pausing to understand it, without taking a moment to see how it might actually work. We are map makers who, upon finding that the city doesn't quite fit our map, an extra building here, the river not quite where we expected it, we proceed to remake the city to fit our map. So consider these remakings. I said that the commons that fuels innovation is the commons that exist at the logical layer of the net. This is the commons constituted by the principle of end-to-end. It is the commons that get built into a set of protocols that don't discriminate. It is the neutral platform upon which innovation happens, and this neutrality is built into the code. But this code is not given. The code governing the network is not fixed. The code that governs at one time can be replaced or supplemented by different code, and more importantly, there are certainly forces, people, who connect to the net who don't want the net to obey this fundamental principle of neutrality. There is no brand called the internet that carries with it a set of assumptions about openness and balance. There is instead a basic set of protocols that anyone is free to supplement with protocols added on top. Anyone is free to change it, and some important people are now changing it. For example, think about broadband service. As the internet moves from narrowband to broadband, the physical layer across which the internet is served becomes different. It's no longer the regulated telephone company. It's the unregulated cable company. Now, as cable converts itself into opening up to the internet, it is modifying the architecture of the internet in an important way. While the essence of the common of the internet was neutrality and simplicity, the essence of what the broadband cable internet will be is the power to discriminate in content and services. The aim of this form of internet access will not be openness and neutrality. The aim of this form of internet access will be control over the content that gets played. For example, cable companies make a lot of money streaming something called television to televisions. Some people think you could stream television to computers. So they develop technologies for streaming this video content to computers, and cable companies respond with rules that say no more than 10 minutes can be streamed to a computer at any one time. When asked about this restriction, and acting smartly, they say things like congestion. We're trying to minimize congestion. But when honest, which is not quite the same as being smart, they say something like this. As AT&T executive of the internet said, "We didn't spend $56 billion on a cable system to have the blood sucked from our veins." Broadband providers will insist that this content and control over content is their right, that nothing should interfere with their right to layer onto the free logical layer another layer of control. And a budding line of First Amendment doctrine embraced and pushed by judges in the DC Circuit strongly supports this claim. Indeed, in a kind of Blade Runner-esque-like transformation, we are seeing a whole new body of First Amendment law created. Remember, one of the millions of amazing puzzles in that extraordinary film was this slow recognition that the machines were human. Well, here too, with the cable system, it is the increasing recognition that these systems, which really just deliver electricity in weird patterns, are in fact speakers, not machines. And wires, plus this little bit of logic, entail the content is the press. And calling it the press means that now the full support of the First Amendment must stand in to defend the right of the press to do whatever they want with their wires, which means the First Amendment guarantees them the right to assure control of their architecture however they want. And hence we should expect, as the internet moves to this broadband, that these rules governing these providers will be different from the rules that govern the providers of the internet across narrowband. Unlike the telephone company, these providers will be allowed to discriminate. Allowed to discriminate, they will. And when they do this, this feature of the internet, this feature of an innovation commons, will be removed, enclosed, chopped up, and sold off, with the consequence that innovation here will be different. That's a change at the logical layer, but that's not the most important change to notice, especially here. There are changes at the content layer, and these are a bit harder to describe outside of here. The content I want to focus on here is the content controlled by copyright law. Ideas, or more precisely, inventions, get controlled by patent law. Context or expressions of ideas is regulated. Content or expressions of ideas is regulated by copyright law. Copyright law has changed. In the sense that an acorn becomes an oak tree, copyright law has changed. So we should remember a bit about what copyright law was. Here's what you've taught us. When the United States was formed, the Constitution gave Congress the power to grant, quote, authors, quote, exclusive rights for their, quote, writings for a, quote, limited time. 2, as the Constitution expressly states, promotes progress. The Promote Progress Clause is unique in our Constitution's enumeration of power. Every other clause leaves a relationship between the purpose and the means unspecified. Only this clause says what its power must be used for and what this power is. The first federal copyright statute was enacted in 1790. That act regulated printing of maps, charts, and books. It granted the copyright holder a term of 14 years initially, while in principle anybody could vend in violation of this law. There were only 127 printing establishments in 1790. Copyright protection was not automatic. Registration was required. Most of the early registrations were for scientific or instructional texts. Between 1790 and 1799, 13,000 titles were published in the United States. Only 556 copyright registrations were filed. More than 95% of published work, therefore, fell immediately into the public domain, including, of course, 100% of all foreign work. For our outrage at China notwithstanding, we should not forget until 1891, foreign copyrights were not protected in America. We were born a pirate nation. Thus, the law was slight, and so too was the actual scope of the protection slight. Copyright did not protect derivative works. You could translate or adapt or abridge something or set it to song without the permission of the copyright owner. The monopoly rights that the 1790 statute granted were essentially protections against pirate presses. The target of the regulation was the American book, simply reproduce it without compensation. This law says, you pirate presses must focus your energy on stealing British and French. Now, copyright law has changed. It's no longer limited to maps, charts, and books. It touches practically any creative work reduced to a tangible form. It covers music, performances, architecture, certain designs. It protects machines written in words. We call that software. And words written on machines, we call that the internet. And it protects these creative acts no longer for an initial term of 14 years. It protects these creative works for the life of the author plus 70 years, which in the case of Irving Berlin means 140 years. It protects this work not contingently, that is, not upon registration. It protects it and all creative work automatically for a term that does not have to be renewed for a life that exceeds the life of the authors. And it protects it not just against pirate publishers. The scope of copyright now protects an extraordinarily broad derivative right. The right to translate with some works, the right to perform, the right to adapt, to make a play, to make a movie. All of these are rights that are now included within the original sparse, exclusive rights that the original Copyright Act granted. And finally, because it doesn't protect only against private publishers, because in 1909 the statute shifted its terms to speak not of publishing but of, quote, copies, and because the technology of copying has now exploded to cover just about anything done with a computer, the reach of this regulation is no longer the equivalent of 127 publishers. The reach of this regulation on the right to speak extends to everybody who uses a machine. This tiny regulation of a tiny portion of life in 1790 has morphed into this massive regulation of anyone who has any connection to the most trivial of creative authorship. Now, no doubt, and I certainly believe, much of this expanse in copyright over the past 200 years is completely justified. Though the framers didn't protect music, it would have been wrong for us not to protect music. I realize there are those on the other side, those who note that our culture has produced the likes of Britney Spears and Madonna, while the framers' system of non-protection produced Beethoven and Brahms. But I'm not on the side of free music. If free music means that artists don't get paid, in my view the issue is not whether artists get paid, but how. And Congress has been correct in its efforts to extend rights to assure that artists of all sorts get paid so as to assure a sufficient incentive to produce art. Thus, we shouldn't notice this expansion simply to oppose it, but to recognize its inertia. Control is the direction we are moving, and our velocity has been set and it is high. something big will have to happen if this inertia towards control is to be checked. Something significant in the culture must block it. If the inevitable it promises, the inevitability of perfect control over content, is to be avoided. Instead, something big has happened in our culture that simply accelerates this drive to perfect control. And paradoxically, and the Boylesque in us will love this paradox, that something big that will push copyright to perfect control is this architecture of freedom that we call the internet. For before the internet, in my humble view, there was really little reason to worry about this emergence of this system of control. I realize that's a controversial view here. David Lang was lamenting the commons long before any of us had linked with HTML, long before Hillary Rosen became a chat room slur. Lang was building outrage at the tendency of IP lawyers to overreach. Indeed, in a passage from his Reclaiming the Public Domain, Lang captures the essence of where we are now with the style and authority that reminds us of Charles Black's account of Brown versus Board of Education. Lang tells us of what we all know, but reminds us of how the legal system makes it impossible for us to say what we all know. This is Lang. The defendants, in some extreme case that he's describing, of course, were obliged to take each of these claims seriously and to respond to them with earnest denials rooted firmly in the law. But I, Lang, am free to recognize them for the utter nonsense that they are. Legitimate works deserve protection from real threats. But claims of this kind, Lang writes, are so extravagant in relation to the reality from which, in theory, they ought to spring, that one is tempted not merely to dismiss them as nonsense, but to suggest in addition that one day one of them might be made the subject of a serious counterclaim for punitive damages rooted in the sort of tort designed expressly for the purpose, perhaps to be termed unconscionable overreaching. Thus, the practice we can't escape seeing today is, of course, a practice that has been noticed by many from time immemorial. The extremes of the RIAA were not invented by the RIAA. Lang retells in the same article the extraordinary story of Warner Brothers threatening the Marx Brothers when Groucho was considering a production titled A Night in Casablanca. For, of course, Warner Brothers believed it owned the name Casablanca, which inspired Groucho to respond that he believed, since the Marx Brothers predated Warner Brothers, that he owned the word brothers. Yet there's a difference in these blusterings of lawyers from yesterday. And the difference is in the code. Not in the code architected by East Coast coders, those legislators in Washington, but in the code architected by West Coast coders, the code of software and the controls built into it. The difference is that now these systems of control can be built into an architecture that must recognize them. The encodings and control, as Jamie Boyle puts it, following Foucault, get inscribed into the wires. And when this discipline gets encoded into the wires, then this discipline is bizarrely more important than when it is simply the overreaching of lawyers. Now when the overreaching of an e-book says that you can read this book on a Windows machine but not on a Macintosh, it is something more than bluster. It is a set of controls with the power of mathematics behind it. We call that encryption. And now these controls have the power of law to defend them. We call that the Digital Millennium Copyright Act. This layer of control is new in the game. This layer is exploding and the law is expanding to back it up. And hence now, just at the moment, that a technology could enable 1 billion lifelike innovations, 1 billion IMAX crafting movies by remixing culture from the past, just at the moment when a technology could make real the idea captured in the Apple commercial, rip, mix, and burn. After all, as the commercial says, it's your music. Just as this is happening, that technology is taking these freedoms away. The very same iMac, which Apple tries to sell with this picture of freedom, rip, mix, and burn, is encoded with software to handle DVDs such that you can't rip, mix, and burn the DVD from Hollywood. Try to rip, mix, and burn that stuff and the system will quickly crash. Not that that's uncommon, but still. Control of that content has been encoded, and this system of, quote, freedom has been encoded to respect that control. This is the conflict between two pictures of the future. One, the future of imperfect control at the content layer, music that gets ripped, mixed, and burned. The other, the future of perfect control, of DVDs that get ripped, mixed, and burned only as Jack Valenti allows. And my bet is with the future of control. For as well as an infrastructure that can have control layered onto the internet, and as well as a code that can build control into the content, we call that trusted systems, and as well as the law that will back up this control that gets built into the content that gets served across the internet, we call that the Digital Millennium Copyright Act, as well as all these technologies of control, more importantly, a better reason to bet on the future of control is a fact about our culture. It isn't West Coast code that will matter the most. It isn't East Coast code that will make the real difference. The real issue here is culture and its code. The real power is in a set of ideas still taken for granted by us. For this is what I spoke of at the start of this talk, and it is this that will define the end. Ideas that are taken for granted, those that unquestioned live in this culture, that to question would render you an alien, these ideas are the ideas that will make perfect control our future. For these ideas take for granted the, quote, property in intellectual property. These ideas have lost the distinction that our framers made clear by speaking as they did not of intellectual property, but of monopolies and exclusive rights. That's what a copyright or patent is, isn't it? Right? A government-backed monopoly, not over a rivalrous or scarce resource like land or apples or heated homes, but over a non-rivalrous resource that the Enlightenment taught us should be shared among more than the church. IP, intellectual property, is not property, whatever Frank Easterbrook says, but this truth, this fact, is lost upon us. And so deeply is it lost that we don't even notice the irony it produces in this culture. We speak of the commons as if it's only something associated with tragedy. We recall the public domain as if it were simply an echo from some romantic past. We embrace, as Carol Rose says, the idea that the whole world is best managed when divided among private owners, and then we proceed to divide the whole world among private owners. Most Americans agree with the Disney Corporation that Mickey Mouse is Disney's now and forever. They don't even notice the irony when Disney makes millions off of Hugo's creation, A Hunchback of Notre Dame, or off of Prokofiev, or off of Pocahontas. So invisible is the public domain to us that we don't even see it when it is everywhere around us. So invisible is the idea that the free might matter to creativity, that when it is enclosed, we are convinced this is progress. Our future is this. The free speech clause of the First Amendment will be read to entitle those who own the wires to to change the logical layer and make it owned as well. The free competition principle of the Sherman Act will be read by the same circuit, we might notice, to entitle the owner of the platform that most affects this logical layer, that one company whose name I have not mentioned, to code that platform to discriminate as it wants. And the free culture that we have seen flourish in this commons built by the internet will be captured and controlled again by those who control most of content and by those who succeed in Congress in expanding their control from the imperfect to the perfect. The future will get built by an idea, the idea that property is good, so more property is better. It will get sanctioned by a culture that has forgotten the distinction and that is so blinded by what it has forgotten that it doesn't even notice when the most extraordinary innovation that our culture has seen since Thoreau was a name that most Americans could spell, is built not on a culture of perfect freedom, not in a world where every layer is in the commons, but also not on an architecture where control is the rule, not on an architecture where every layer is owned, but instead on an architecture that mixes freedom and control, that freedom builds property with a commons around it, that got its life from this mix of property and the commons. At every layer, we are displacing the free with the control. And the reasons for this displacing are not hard to see. This architecture of innovation that we call the internet threatens the systems of control that thrived before there was such a thing as the internet. This architecture of innovation threatens interests that are challenged by the opportunity for decentralized cultural production. And these interests have rallied to undermine what is special about this innovation. Now, this is nothing new with the internet. This is the battle between old and new, and always the old succeed in getting the support of the government against the new. And not just in America, but from time immemorial. In his extraordinary work, The Prince, Machiavelli wrote about the same thing. He writes, "Innovation makes enemies of all those who prospered under the old regime, and only lukewarm support is forthcoming from those who would prosper under the new. Their support is indifferent partly from fear and partly because they are generally incredulous, never really trusting new things until they have been tested by experience." We allow these changes. They don't just happen. We stand back as they occur. They don't happen in the night. We let them occur because most of us believe they should. Control, we believe, is good. More control is better. These systems of control are ways to make sure the better becomes the emergence from the good. It is an attitude and a blindness and a pathetic resignation that permits these changes. So enamored are we with the invisible hand, so convinced are we with the genius of property, so blind are we to what makes innovation possible that we allow the undoing of the most significant chance for something different than we have seen. When I talk about this loss in other places, most people don't really get it. They clap politely and then they ask, what is innovation? You haven't defined it. What's the good in innovation? What do we really lose when control is the norm? What's to be gained from freedom? These are people who can't imagine a world where culture is anything but served. These are people for whom the idea of cultural production is only ever associated with the state, as in China, or the corporation, as in the production department. These are people who can't imagine culture being reproduced and recreated by individuals again, or by small groups working together with technologies that enable the remaking of culture. These are people who have not seen the films of David Lang's students, who have not heard the politics in Jamie Boyle's writings, who have not begun to understand the lessons of harm to science taught by Jerry Rescher. These are people who have not been to Duke. So I come to Duke to do little more than report on a war that you are losing. To report on a culture that can't see the potential that this architecture presents. To report on politics that scorns anyone who questions this vision, this Uber-vision of perfect control. The irony astounds. We win the Cold War against state control so as to retrench this system of control in the name of the market. We fight the battle in the name of free speech only to have those very same tools turned over to the arsenal of those who would control speech. We defend the ideal of property, and then it is confused and its limits lost, and it is extended to reach a space that none of our framers would ever have imagined. We move through this moment of an architecture of innovation to once again an architecture of control without noticing, without resisting, without question. You may notice this is a contradiction in us. It is a contradiction in our culture, in our tradition. You might then be tempted to repeat my favorite line from Jamie's book. I have nothing against contradictions. Some of my best friends are contradictions. But the contradiction is not a friend. We have no reason to respect it. We have all the reason in the world to change it.
Thank you, Larry. We hope you will join us for a wake on the third floor.